Hi. Hi. I feel giddy. I don't know why. I'm still a little congested. I'm still a little congested. I feel giddy. I've been gone for a week. I feel like I've missed, I don't know. I feel like I've missed the world. Um, I have been watching Donna Adelson on the down low. I enjoyed the hell out of that trial. But today, today we're here for baby Evelyn Boswell. I want to say thank you all for being so patient with me for this last week. I know I kept changing those times because I kept thinking, I'm gonna get better, I'm gonna get better, I'm gonna get over there, and I'm gonna sit on that chair. I'm gonna do this where I'll be okay. And it just didn't happen. It just didn't happen. So so I am here. I'm feeling some better, still a little congested. Um, it is what it is. Had a rough few days, but I'm good. I'm good. Look, K Swat even is here. Look at there. Hey, love. And I see Cindy pop in. um, it is Friday. Y'all know I don't normally do lives on Friday. Hector's home, so you might hear a TV in the background. Um, it is what it is. It's my house. It's my crazy. Oh, look, I got flyaway hair going on and everything, y'all. I, oof. Anyways, it'll get small. Y'all won't notice all the flyaways in a few minutes. So, what I wanted to do today was I wanted to start off with um, the Evelyn Boswell law. Okay, that's what I wanted to start with, is the Evelyn Boswell law, because this baby lost its life. She was a beautiful soul, but there is something that came out of it. One of the best things that I've seen in a while. You know, and that's what I look for in some of these trials, is positive things coming to light. Positive things. And look, even Muffin showed up. Hey, baby girl, Baba loves you. I'm feeling better, by the way. Um, but so Evelyn Boswell's law became official, and I believe it was in 2022. And I wanted to go over this and let them. He's going to describe the law and go over the basics. You're going to have, in Tennessee, they're required within 24 hours to report their child missing, because this was a factor with Evelyn becoming missing. So I want to play this.
Today, Evelyn Boswell's law becomes official. The legislation is named after the Sullivan County toddler. The TBI issued the Amber Alert for Evelyn February 19, 2020. Her body was found a few weeks later on family property. News Channel 11's Ashley Sharp explains how Evelyn's death has inspired change.
Josh, when the Amber Alert went out for Evelyn Boswell last year, police learned early on that she had actually not been seen by some family members for around 2 months. Well, thanks to this new legislation, it's now illegal in Tennessee to not report your child who is 12 or younger missing within the first 24 hours. It's something good to come of a tragedy.
She's probably smiling down from heaven right now thinking about it.
Evelyn Boswell's law is now
I'm gonna back that up just a second. I want to make sure I heard that absolutely correctly. I think she said under the age of 12, I believe. Any child under the age of 12 has to be reported missing within 24 hours.
Actually not been seen by some family members for around 2 months. Well, thanks to this new legislation, it's now illegal in Tennessee to not report your child who is 12 or younger missing within the first 24 hours. It's something good to come of a tragedy.
She's probably smiling down from heaven right now thinking about it.
Evelyn Boswell's law is now Tennessee law. It requires parents to report their child missing within the first 24 hours or be charged with a Class A misdemeanor.
It just amazed me that we didn't have something on the books already that addressed this.
Representative John Crawford of Kingsport sponsored the House version of the bill. It passed unanimously in the Tennessee House and Senate.
It's a step in the right direction.
The difference this law would have made in the Boswell case, police could have arrested mother Megan Boswell on this charge much earlier for not reporting Evelyn missing within the first day.
That first 24, 48, 72 hours is crucial in the recovery of a child. So, as you know, 2 months goes by. You don't know where they're at, where they've been.
Police would ultimately arrest her on charges of false reporting and later charge her with murder. They say having this law in place sooner could have helped their investigation, but most importantly, hold her and other parents responsible for neglecting their child's safety.
We definitely needed this law, and I think it's going to help other police chiefs, sheriffs, law enforcement agencies, first responders in the future. I really do.
This case captured the heart of the Tri-Cities community.
I'm hoping this bill will help us heal. I hope it will help our community heal.
Now baby Evelyn's legacy is one of bringing justice for other children.
This is not going to affect our case with little Evelyn, but maybe it'll prevent this from happening in some other community, and they won't have to go through what we went through.
Evelyn's mother, Megan Boswell, remains in the Sullivan County Jail on charges of felony.
Okay, which she's no longer charged. She is a convicted felon. Her sentencing is today. What I do have pulled up is I have just it's a 30-minute video that kind of goes over, just for a refresher, if y'all are not, if there is anybody, which we're all true crime enthusiasts, or we wouldn't be here. Come on, let's all face it. But if you don't know who Megan Boswell is, I'm going to play this. It's like 30 minutes or something, but we'll kind of skip. I might skip a little bit. It kind of goes over. It's her being grilled by detectives. Well, you know what? Wait a minute. Hang on just a second. Hang on. In the dense forests of the Ardennes, Carpenter was stalking his next target when a sudden blow to the head knocked him out. When he came to, he was lying. There was another one that I had pulled up and I can't find it. The smoke grid was inspected with sniper rifle, while the other had the pistol. Okay, I'm gonna play this one.
Tennessee versus Megan Boswell, 72869.
Okay, it won't let me scroll. What is it doing? This was when she appeared in court for the first time after they found Evelyn's remains. We're going to watch through this for a few minutes. The sentencing is supposed to start at 12:30. I do have it pulled up in the background. It says it's got 22 minutes before it starts. This video is 19 minutes long. Sorry. And so this was the basic court hearing when this first went down. So, and she is convicted. So we will get to that. Okay, I don't remember her almost falling like that. I'm sorry.
You get to the table, right standing, raise your right hand. Each one swear affirm testimony about to give you the truth, the whole truth, and the truth, and information on each one after the event. Yes, Your Honor. That's it. Ma'am, you're not working, you're not receiving any government assistance.
You know what? I didn't do any of my intro. Hi, my name is Sheila. If you're new here, this is the Rubber Raw Motto Room, where we do kind of crazy things. We're snarky, we're sassy, we're sometimes a little rude, but I am me. I am honest. I'm sorry. I didn't even get to tell y'all. Hi, welcome in. Chat is open. You can talk about anything. Opinions are welcome. I always keep an open link. If anybody would ever like to come up and talk about any of the subjects, you're always welcome. You could always say, drop a link. I will put a link in chat and we can always talk about it. So I did want to put that out there. All opinions are welcome. We are a very open channel. So with that, let's go back to this.
You have a vehicle worth about $10,000 with you owe $7,000 on it, is that correct?
I no longer have that vehicle, but I have it on it for now 6 months.
You left the other asset questions blank, I'm gonna hand that down. If you don't own the piece of property, put a 0 or NA or something in there. You put NA on the other asset questions, ma'am, or you tell me you do not own any property at all.
No, sir.
I'm gonna appoint public defender, assess particular administrative fee, we take 14 days after release. She's been bound over for a false report. There's no indictment. No, not public defender. Did I write that? That's happened. Mr. Sproles, do you take an appointment?
Yes, Judge.
Of course, I'm gonna appoint Brad Sproles.
Thank you, Your Honor.
Thank you. The case was scheduled for May 8th. The state has filed a motion to increase bond, which Mr. Sproles, anticipating the appointment today, has agreed to hear today. Is that still the case, Mr.
Judge, it is, and anticipating being appointed, I've prepared a response to that, and I've provided a copy to the state. If we could mark that file.
Of course, the other thing, it's not. We'll go forward with the motion, but another issue is that Ms. Boswell is being held on contempt out of the juvenile court, Bristol Juvenile Court.
We're aware of that, Judge.
You know, we have witnesses. Yes, sir, we do. One witness. Brian Fraley. State your name.
Brian Fraley.
Solemnly swear affirm the testimony about to give you the truth, the whole truth, and the truth.
Yes, sir, I do.
State your name for the record.
Brian Fraley,
And where are you employed?
Tennessee Bureau of Investigation.
And what do you do there?
I'm a special agent criminal investigator
How long have you had that job?
since 2006.
And were you assigned to investigate the disappearance of Evelyn Boswell, assist the Sullivan County Sheriff's Office in that task?
Yes, sir.
And do you know when that investigation began?
Yes, sir, February 18th of 2020.
And how did that investigation begin?
It was originally a DCS referral that Evelyn Boswell was missing, but also went to the Sullivan County Sheriff's Department.
And did you have a date of when, according to the referral, when she'd last been seen?
As December 26th, 55 days from the time of the report.
And did you obtain the name of the mother and the legal guardian of Evelyn Boswell?
Yes, sir, we did.
And who was that?
Megan Boswell.
Is she here in the courtroom today?
Yes, sir.
Can you identify her?
Yes, sir. She's to my right here.
She was next to Mr. Sproles.
Yes, sir.
Did you determine from the referral the age of the child at the time of the disappearance?
Yes, sir.
What was that?
That was about a year.
Now, as part of the investigation, was Megan Boswell interviewed by you and other law enforcement agents during the pendency or during this investigation of the disappearance of Evelyn Boswell?
Yes, sir, she was.
And you conducted your interview one-on-one with her on, or at least you lived with the lead interviewer on at least one occasion.
Yes, sir, I did.
And did you review the other interviews or statements of interviews conducted by other law enforcement agents
Yes, sir.
of Ms. Boswell? Based on her responses in your investigation, did you come to the conclusion that false statements were made by Ms. Boswell?
Yes, sir, several.
And as a result, she was charged with at least one count of false report by affidavit complaint in Bristol Sessions Court. Is that
That's
correct?
correct. Yes, sir.
And what was the effect of the false statements on the investigation?
Because an Amber Alert was issued, various resources would spend man hours, time, but the most crucial thing was time lost.
And what was that?
Anytime an Amber Alert is issued, time is of the essence.
Now, these resources were not just by TBI, is that correct? Were there
No,
other
sir.
agencies involved?
TBI, of course, all Sullivan County Sheriff's Department, criminal investigation team, FBI was brought in, dozens of agents and investigators.
So I want to go to March 6th this year. And was there a search conducted at the residence of the Boswell family on that date?
Yes, sir, there was.
And when I say Boswell family, we're talking about the defendant's father, brother, and grandmother. Is that correct?
That's correct, yes, sir.
And what was found upon that, conducting that search?
There was a body, a child, approximately a year and a half old.
Even though it's not been positively identified by forensic testing, did that child appear to be the same age, same size as the photographs and the information you obtained even from the defendant about the child's characteristics?
Yes, sir.
What else was found there?
The clothing with the prior interview of Miss Boswell, clothing described in that interview was exact clothing that was found on this child.
What else was found there?
There was various child clothing, diapers, toys, that kind of thing that would belong to the child.
Based on your conversations and observations of the defendant during the investigation, did she have does she currently have did she then have a residence? Did she have a place where she lived and stayed?
No, sir, she did not.
Is she currently employed?
No, sir.
Would she be able to go back to where she was working before while this investigation was pending?
Most likely not.
Okay. Were you aware of any out-of-state and out-of contacts during the relevant dates in this investigation that the defendant has with other individuals?
Through the investigation, we identified 3 states, Virginia, North Carolina, and Texas.
Her mother drove to North Carolina, is that correct?
That's correct.
And mother's boyfriend, Mr. McLeod. And did you also determine that the defendant had made trips out of state?
Yes, sir.
Where was that?
Texas.
And when was that time?
The fall of 2019.
Also, were the trips out of town made outside the Tri-Cities?
Yes, sir.
Where was that?
Knoxville, Gatlinburg, Sevier County.
That's all the questions we have this time.
Agent Fraley, you were describing trips outside of Sullivan County. You said Texas. Do you know when that trip occurred?
I believe it was October 2019.
Okay. Prior to the events here.
Yes, sir. Prior.
And then you described trips to Knoxville or Gatlinburg.
Yes, sir.
Do you know when those occurred?
I don't have the exact dates on a couple of those.
Okay. Can you say since the investigation has been ongoing that she's been out of state?
To my knowledge, she is not.
And then during your investigation, did you have a chance to look at the criminal background or any prior convictions from Ms. Boswell?
Yes, sir.
And what did you find?
No criminal history.
Okay. She's never been convicted of anything. No, sir. And did you see that she never been charged with any type of failure to appear?
You know, I do find that very interesting. She had no criminal history whatsoever. I don't know if everybody realized that. This young lady at the time had no criminal history. What on earth had possessed her to do this, to take her child's life? It is just, it's ghastly. I don't understand it. I never will understand it. I love my child. I don't like her all the time. love your muffins, but I love her regardless. We have our moments, you know. I mean, it is what it is, but you never harm a child. Never.
That's correct. You described that she has some contacts out of state. Does she also have contacts here in Sullivan County, family members?
Yes, sir, she does.
Could you say that the majority of her family contacts and relationships are here in Sullivan County?
Yes, sir.
That's all the questions we have.
This one, independence investigation, she was in Virginia. Is that correct?
I'm sorry.
She was in Virginia during the time of the investigation of disappearance. She did go into Bristol, Virginia.
Yes, that's correct.
That's all.
That's pretty good.
Ms. Ross.
While they approach for a sidebar, a long sidebar at that. Megan over there in her Crocs, her orange Crocs, and her pretty gray stripes. Okay, Indy, we're here, hon. Do your thing, love. I'm here.
During your investigation, did Ms. Boswell make any culpatory statements with regard to the death of Evelyn Boswell?
You say culpatory or culpatory? Yes.
I'll ask the question. Either party have questions? No, not this one. Any other proof?
No, you're on. It's like,
Any proof? While the court is aware from the proof today that Ms. Boswell does not have prior criminal history, does not have a history of failing to appear for court appearances, has family ties in Sullivan County area. The proof also is that she has ties to Virginia and ties to Texas, at least that she's gone to those two states. I'm not nearly as concerned with the fact that she's gone to Knoxville, Sevier County. I am concerned with that she has, especially the ties to Texas. The court's also considered that during the pendency of the investigation, Ms. Boswell has made correct statements with regard to the death and I lay the positive and negative factors that we have to consider for bond. Length of residency, employment, proof was that she's not working now, which is frustrating, but she wouldn't be able to work the same job. We discussed family ties and relationships, reputation, character, mental condition. I think that's going to be a negative factor, given the statements that she's made, implicating herself in the child's death. She has no prior criminal history. Nature of the offense is here is false statement that is regarding the surroundings, the disappearance of what we believe to be ultimately the death of the child. From listening to the proof and reading the affidavit, the probability of conviction for false statement seems to be high. She has no criminal record. No one's testified here today that members of the community are vouched for her. Weighing the positive and negative factors, courts have the opinion the bond should be increased. It'll be increased to $150,000. Now, General, when's this case going to go?
Okay, so at that point, yeah, it was in February, which I'm gonna pull this up. This was let's go to this one. We're still waiting. It's saying any minute now it should go live, but I just want to review this real quick. This was Tennessee mother Megan Boswell found guilty of murdering her mom one-year-old daughter Evelyn. This was February 13th, 2025. Tennessee jury found the mother of murdering her daughter, Megan Boswell, convicted on the slaying of 1-year-old Evelyn Boswell. It reports that Megan is seeking a new trial. Not going to happen. I mean, she can appeal, whatever. Jury deliberations began Wednesday after closing arguments wrapped up. During the trial, Tennessee TBI Senior Special Agent Bryant Fraley testified that law enforcement received a phone call from Tommy Boswell, Megan's father, to search the family's property on Muddy Creek in Bluntville. This is just a rundown in case you don't know what was happening. Yes, and it has been a while since the actual, since she was convicted. I mean, she was convicted in February, and here it is, September. Actually, that's only 6-7 months. So I don't know. I mean, yeah, it is a long time to actually get to this point. But I know they had to do PSIs and all that stuff. So on the property, Fraley and other officers searched what they described as a playhouse inside the structure. Investigators found several items, including a white trash can. Inside, investigators found the body of Evelyn Boswell. Her body was wrapped in a blanket and aluminum foil, Fraley says. It appeared as though Evelyn's body was shoved in the trash can. The defense argued that medical examiners could not rule out that Evelyn could have died from sudden infant death syndrome or another medical condition. SIDS is the sudden and unexplained death of an infant that usually happens during sleep. She can't face the truth about what she has done, said Deputy District Attorney William Harper. She can't face what she's done to that child, discarding her like a piece of garbage. Evelyn was reported missing in February of 2020. The following month, Evelyn's remains were found on a family member's property. Boswell was found guilty on all 19 charges she was facing: first-degree murder, felony murder, aggravated child abuse, felony murder, aggravated child neglect, aggravated child abuse, aggravated child neglect, tampering with evidence, 11 counts of false reporting, abuse of a corpse, failure to report a death under suspicion, unusual or unnatural circumstances. A jury recommended a sentence of life in prison for Megan Boswell, and Boswell would be eligible for parole after 51 years. She would be around 69 years old. A sentencing date of May 22nd was set. I don't know what happened on May 22nd. It is now September 5th, and we are just now getting to that. I'm going to go ahead and play this small video.
The fate of Megan Boswell will soon be in the hands of the jury. The day began with the prosecution resting its case. The defense quickly followed, resting their case without calling a single witness. Megan Boswell chose not to testify. News 5's Liam Bridgman has been in the courtroom today. Liam, what can you tell us about what you've heard today and what comes next?
Yeah, Jonia, after a brief recess, Judge Goodwin read from an 81-page document. That is the jury charge. That's the set of instructions or directions for the jury as they head toward deliberation. Within these instructions, Goodwin went through all the charges that Boswell has against her, as well as what charges could be reduced to. For the charge that holds the most weight, that's the first-degree murder charge. Judge Goodwin instructed the jury that they must agree beyond a reasonable doubt that 1, Megan Boswell unlawfully killed Evelyn Boswell, 2, Megan Boswell acted intentionally to kill Evelyn Boswell, and 3, Megan Boswell planned to kill Evelyn Boswell in advance. Again, throughout the trial, Gene Scott of the defense has argued that there is no conclusive evidence that Evelyn Boswell was alive when placed in the trash can. He also has argued that there was no medical evidence, that Evelyn was murdered as opposed to dying of natural causes and then being placed into the trash can. It's also important to note, even though first-degree murder is the charge presented, the jury can decide on a lesser offense. Now, we have asked our legal expert, Julie Cantor, about the potential options in this case.
Degree murder and whether or not the state has proven every element of that crime defined in the jury instructions by the judge beyond a reasonable doubt. If they determine that, yes, the state has proven first-degree murder beyond a reasonable doubt, then they can return a verdict of guilty without considering anything else further. Now, if they're in their deliberations, they determine there's reasonable doubt and the state has not proven the elements beyond a reasonable doubt, then they go to the lesser included offenses. It's a bit like a rung of a ladder. And if in the order of consideration, they look at something lesser than first-degree murder and then determine that fits, then they can return a guilty verdict on that charge.
Court is currently in recess for lunch, and when we get back, we're set to hear the closing statements from both the defense and from the state. You can continue to follow the latest on our homepage at WCYB.com. Live in Sullivan County, Liam Bridgman, News 5, WCYB.
I'm Christine for.
Okay, so now we're at this point where it should be going live any minute. So we can just kind of hang out. Anybody got any thoughts on this? Anybody? I mean, you know, it did take a while to get here, but we are here. We are here. And I really am glad about the baby Evelyn law. My words are just not working today, y'all. It's been a week. Okay. Be patient with me. But yeah, I would like to see, and this is just me talking, I would like to see that kind of law be taken up on other states. I don't know. You know, we have a baby Moses law, which we've talked about that in the past, the baby Moses law here in Texas. But there needs to be accountability for when the children go missing. And I find that very, very important. God, there's so many missing children. There's a missing child case I want to talk about, but I can't. I have to keep my words to myself. Yes, I need to keep my words to myself on this certain missing child case. Yeah, it is. How many people are harming their own children, and what's causing this? What is what's causing this? Why are these young parents, I say young parents, even older parents, are having these type of reactions and actions and not thinking about consequences, what triggers them? We did a stream, a week ago or so, maybe 2 weeks ago, talking about triggers and things that set us off with mental health and stuff like that. And this goes back to mental health. And I had said, here I am commenting again about my own life. I had that one incident where me being overweight, over 300 pounds, only way I knew to confine my child was to sit on her. I could have killed her. I could have suffocated her. I was not in my right mental state. I was not by any means in my mind when I did that. I was angry. I was all over the place. Something had triggered me, and the only way in my mind I knew to restrain my child was to sit on her at 300 pounds. You don't do that. What the hell was wrong with me? I wasn't in my right mind. That was, oh my God, Muffin probably already left here. She's probably not chatting anymore, but that was 22 years ago or something like that. And I would never do that now. I look at it and go, oh my God, what the hell was wrong with me? You just don't think about it. And yes, the Haro child, that is a horrible. And now both of these parents with the Haro is like, no, we didn't do it. They still haven't found a body. The guy led him to a false spot. The body was not there. There was misinformation all over. And this is why, y'all, I'm going to be totally honest with y'all. This is me being honest. I have problems reporting or talking about cases that I don't have all the facts yet. And with that Haro case, I want to talk about it so bad. But there's so much misinformation out there and speculating and guessing and stuff like that. And I don't want to do that. I don't want to just guess. I need facts. If I'm gonna put it out there, it's got to have a fact behind it. It's got to be, there's paperwork, there's a trail, there's this. And with that Haro case, all I was seeing was, okay, the dad saying this, the mom saying this. There's on the Tierra, which is another YouTuber, is out there, and he's giving information what he thinks is fact, but he's talking to neighbors. So do the neighbors really know? Are the neighbors saying, yes, this happened, or we saw this? But so that's my problem. That's just me. I'm sorry. I'll go back to reading messages. I see, this is squirrel. I went off trail. Oh no, it's no excuse, but COVID and lockdowns brought on the worst on a lot of folks. Or did it just break? Okay. And I can say, when COVID happened, my whole world changed. That's when I got my mental health back in order and started living my life right, cleaned myself up. So there was good and there was bad during COVID. I mean, and I've seen so many horror stories of COVID. And I look at mine, and I had my own horror story, but I came out on the right end of it. I lost my mom to COVID, March 2020, when COVID started. She was, we went into lockdown. I think it was March 21st. My mom died on March 23rd from COVID. It is what it is. She has one kidney. I have one kidney. It's a fear. She didn't have great kidney function. She also was diabetic. She was overweight. She had so many things going against her, and it happened. It happened. You know, I had to accept it, and I had to live my life. I had COVID. I got it in May of 2020. I only have one functioning kidney. It did take away more of my kidney function when I had COVID. It is what it is. I don't like talking about it. But it happened. I dealt with it. I moved on. So it is what it is. I'm sorry. I got squirreled again, waiting on baby Evelyn. Cindy, I watched a video of a guy who rescued trafficked children. He says the only way to heal is to heal childhood trauma. And you posted. Thank you for posting that Discord. Did you post it in my Discord too? I don't know if you posted it in mine. I haven't looked. I haven't done a lot of Discords lately. Y'all, I need to get back into the swing of things. Squirrel. I'm telling you, I'm all over the place this morning. I haven't done this in a week. I haven't sat in this chair. And I'm telling you, I have not sat at my computer in a week. I didn't even come to my desk. I've done everything from my phone in this last week. Y'all, what is happening with this sentencing? I need to know what's going on. Let me see if I can find anything on it in the background. I'm going to put on a song just to play for a minute while I try to see if I find out. Chips are huge worldwide, but in India, they completely
breathe deep, the air is warm. Stretch your arms, let the world collide. Step outside where the grass is free. Feel the earth beneath your feet. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find. Walk the path where the flowers lead. Hear the whispers of a world serene. Feel the warmth of a gentle breeze. Let your troubles drift with ease. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find. Walk the path where the flowers lead. Hear the whispers of a world serene. Feel the warmth of a gentle breeze. Let your troubles drift with ease. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. to find. Guitar hums in a mellow tune under the glow of the afternoon. Every chord a soothing embrace, guiding you to a tranquil place. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find.
Yes, thank you for that, Cindy. Let's see, the reason for my statement about COVID, this is one deviance here. Oh, y'all, we have sound. I'm going to boost the sound because we're only in one side. Thank you, Denise. We're only in one side, so I boosted the sound. If it gets too loud, y'all say something, because this, y'all know me and my earbuds. One ear works, one ear doesn't. Okay, I'm only in this ear, so hopefully they'll turn the video on so we can see. Can y'all hear?
It is.
Sound check, sound check. You can hear? Okay, thank you, Cindy. I wanted to make sure I wasn't hearing anything, guys. Oh, the other side just came in. Oh, I got stereo. Oh, okay, I'm muting.
This case will take up the State versus Megan Boswell 72869. Long today for sentencing. There was a pre-sentence report filed April the 4th, 2025. A jury convicted Ms. Boswell of first-degree murder in count 1, first-degree murder and perpetration of felony in counts 2 and 3. The jury sentenced her to life. The jury also convicted her in count 4 of aggravated child abuse, count 5 aggravated child neglect, count 6 tampering with evidence, count 7 through 17 false report, count 19 abuse of corpse, count 20 failure to report death under suspicious, unusual, or unnatural circumstances. So we're here on counts 4 through 20 for sentencing today. Is the state ready to proceed?
We are, Your Honor.
Ken's ready to proceed.
Yes.
Because sentencing, the first thing that's up, the state has to
Judge, how are you going to handle the pre-sentence report that we made?
Because of the nature of this case, it's going to be exhibit number 1. I normally don't make any exhibit, but I think in this case.
Fine.
Thanks, sir. Somebody have a copy of it? It's not been marked up? And if you don't, I've got it in the file. I just got to find it. Which file it's in.
Judge, we have a clean copy.
General, the state have any proof?
Yes, Your Honor, the state would call Sheriff Jeff Cassidy.
Raise your right hand, state your name, please.
Sheriff Jeff Cassidy.
Solemnly swear from testimony about to give you the truth, all truth, and nothing but the truth.
Tell the court your name and where you're employed.
Jeff Cassidy, Sheriff of Sullivan County Sheriff's Office.
And how long have you been with the sheriff's office?
Been with them a total of 29 years. This is my 7th year as sheriff.
Okay, and so that means you were sheriff in 2020 during the time of this investigation, is that
Yes.
right?
Yes, ma'am.
And I'm gonna take you back to February 2020. Was Sullivan County the first agency to be involved in the investigation of missing child Evelyn Boswell?
Yes, ma'am.
Can you tell me briefly how Sullivan County how the investigation started?
Missing a child at first, and then once we found out that the last time the baby was saw was in December, we knew he was already behind the curve there. We was probably 2 months away from utilizing the resources that we needed to rescue or recover a baby Evelyn.
Okay. How old were you told Evelyn was at the time the investigation began?
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives and everybody that was responded to this scene and responded to all the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
Okay. When you say around the clock, was there 24/7 coverage
Yes, ma'am.
of this? And are we talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
It's approximately 18 days.
Yeah, from about February 18th to March 6th, I looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime?
Plus overtime.
Okay. So let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, Federal Bureau of Investigation, Virginia State Police, SBI.
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up in North Carolina and other states in Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, try to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
And is the Virtual Command Center, that's where the tips would come in to decide how to then send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. We utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana, from what I remember, and we had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay. She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So in preparation for today's hearing, you were asked to review Sullivan County records regarding this investigation, is that right?
Yes, ma'am.
And the records that you reviewed, were they all maintained by the sheriff's office?
Yes, ma'am. Just the Sullivan County Sheriff's Office.
And the purpose of those was to come up with the manpower that was used,
Yes, ma'am.
to get an approximate amount of manpower and overtime hours, is that right?
Yes, ma'am.
What if the defendant had told the truth on day one?
Yeah,
Objection calls for speculation.
I could ask you a different way. Would you have found Evelyn if the defendant had told the truth on day one?
Objection calls for speculation.
Sustained. Yeah, you need to reframe it. Too wrong.
He said it was too long. What the heck? What kind of comment was that? Was it compound or something? That was a weird statement.
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
Absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could, eat and still work. And they all pulled together during that time and just showed tremendous outpouring of support for our entire agency. And, across the nation, really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And, whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. And, just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. They tried to send some home, and they said, no, I'm not going home. I'm going to work on this case until we find the baby.
Okay, no other questions? Please answer any questions Mr. Scott has for you.
I don't have any questions.
Thank you.
Stay with call, take the last price.
Yes, sir.
You're Matt Price, is that correct?
Yes, sir.
What is your position at the sheriff's department?
I'm Lieutenant in Criminal Investigations.
And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
I think that this case was assigned to me as the lead investigator with the sheriff's office. So I was the lead investigator.
And you worked, the sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including the TBI, is that correct?
Yes, that's correct.
Okay. David Gratz at the time, also two of you worked extensively, that'd be correct. You familiar with the evidence that was collected in the case, the discovery of the body of the victim, Evelyn Boswell?
Yes.
Lieutenant Price, I'm going to hand you some photographs. I'm just going to do this one at a time so we for sake of getting these exhibits in. I'm going to.
Okay, fair warning. I don't know what photographs are going to show. Content warning. Please protect your mental health, your space. Just know if you have to leave, we got you. It's okay.
And your first photograph asks if you can show us, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evelyn was located.
And is that a true and accurate depiction
Yes.
of that scene?
Yeah.
Judge, we would move to make that exhibit number 1 for this hearing. 2, I'm sorry. And I don't know if it's helpful, but that is what the trial was introduced as exhibit number 15. If that's helpful or would create confusion.
Let's just do exhibit 1 from that sentence.
Okay.
2.
Do you recognize what's shown in the photographs that handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the one of the bags had been removed off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would move to make that exhibit 3 for this hearing. Lieutenant Price, would you take a look at the photographs being handed to you and ask if you can identify what's shown?
Yes, this is a picture of the inside the trash can with the blanket removed where you can see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
Judge, we would make that exhibit 4 to this hearing. You recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evelyn was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
So the body has been removed from the trash.
Correct.
bag.
The body's been removed from the trash bag. It's in the trash bag with trash in it. Baby Evelyn is laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 this hearing. Do you recognize what is shown in the photographs that's been handed to you?
Yes, I do.
And what is that? A picture of.
This is the body of baby Evelyn after she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil wrapped around where her head area was.
Judge, we would make that exhibit 6 to this hearing.
Now she's going to shed tears? Excuse me, Megan. I mean, she was found in a trash can upside down with
You
foil
recognize
wrapped
photos
around her and a
just
blanket
Yes, I do.
What is shown in that photo?
in a shed
And
among
this is baby Evelyn
toys.
laying in, still wrapped in blankets laying on a body bag with her arm exposed, showing the onesie that she was wearing.
Is that photo, that one of the photos that was taken at the time the body was recovered?
It is correct.
Judge, we would move to make that exhibit 7 for this hearing. Lieutenant Price, do you recognize what's shown in that photo?
Yes, I do.
What is that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the position of her head and how she was laying when the blanket was removed.
Judge would move to recover Exhibit 8. Please hear.
Cell phone. Hello? Hello? Am I hearing things?
Finally, Lieutenant Price, give you one more photo and asking you to identify that photograph, please.
Yes, I can. This is a picture of Evelyn, one of the last known pictures. We know that when she was alive.
Judge, we could make that exhibit number 9. Thank you, Lieutenant Price. If you would answer any questions Mr. Scott has for you.
No questions.
That's all I had to say.
Judge Boswell would like to make an allocation.
I would just like to say that the state of Tennessee treated me very.
Okay, I need to pause. Everybody take a breath. She's going to make a statement. Sorry, I was doing something in the background. I was sending Cindy some prompts, but okay.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn.
Get out. That did not just happen. That did not just happen.
I'm sorry.
I'm sorry. Anybody want to replay that? I'm sorry. I
would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn.
Factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Miss Boswell is a dangerous offender whose behavior indicates no regard for human life. She had no hesitation about committing a crime in which the risk of human life was high. This court shall bring those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in the trial, as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Miss Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. Detective Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can, so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole and painful part of this is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Megan. Megan chose her life. Megan chose living in the big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter. In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad. Well, then she manipulates law enforcement, manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in a trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime, and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up, relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing is necessary to protect the public from further crimes. And provided the court, as well as Mr. Scott, with the case of State v. Taylor, which was a case in which a small child had been beaten to death. And then the mother basically delayed in reporting, calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, and the results were fatal. Well, Judge, I really, it does not get any more callous and what the defendant did in this case. She turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly is not getting more callous than that. So the state would submit that both those factors are met and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved is an enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance.
Thank you, sir.
Because of the one person who
Thank
should have protected her. So for that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on. And we would ask that they be run consecutive, Judge. Thank you.
Judge, I guess I'll try to address this in somewhat through Mr. Harper did, maybe in a backwards fashion. Ms. Boswell had no prior criminal history when this case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything, and not run consecutive. She'll be in jail until she's 69 years old.
And she can stay till she's 69.
Is she, at that point, is she going to be a threat to society? Society needs to be protected from 69-year-old Megan Boswell. The court should, I guess, first the court has to consider the length of the sentence. She's arranged one offender as to each count. The court should impose I think the sentence is short of the sentence is necessary, so the court is supposed to achieve the purposes of sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole. That's what they want. And we have addressed that issue already in a manner of speaking. I guess, practice law 25 years, not the only jury sentencing I've ever done. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. And I know you're not bound by that on these other counts. But I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges. Obviously, they heard the guilt phase on those and convicted her. So I think that is important to consider. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to the dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all those things kind of go together. And I guess the other thing we have to talk about is what counts merged together in this sentence. I would suggest, of course, that the murder counts merged together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. This is Supreme Court decided that 2014. It talks about cases just like this. Each of these cases, these interviews were basically a continuation of the other interview. And based on the rule of leniency, the court found that even though in that case interviews were made over multiple days with different officers, just in this case, they had to merge. And that's what I think should happen here is all those counts should merge. And I guess finally, I want to address what Ms. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. But I think she's entitled to maintain her defense. She doesn't have to come in here for purposes of sentencing and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for committed sentence. The defendant has a right to maintain their innocence. And to hold that against them and somehow sentence them to more jail time because they don't come in here and say, I did it. That violates due process. It violates the right to a trial by jury, the right to appeal. So I would suggest to the court that the appropriate sentence here should be bottom end of the range. The sentences should be concurrent. And ultimately, she should be
defense doing what defense does.
She's 69 years old. However, that is structured.
Court will be in recess for 15 minutes.
You can cover it up with
15 minutes. So, 15 minutes. I had pulled up, which is only 5 minutes, but this is her mother.
question.
This was her
I
mother.
want to ask you some about.
This was her mother on the stand. You should get your heart checked, Cindy. You kind of made me panic a second there. Okay. You're good. All right. As long as you're good, don't go nowhere on me, Cindy. I need you. Okay. So while they're on their 15-minute break for the judge to do his thing. I wanted to replay this. This is her mother. Her mother feels like she failed her. This was her mother at the pleading for her leniency at her last trial, not her last trial, her only trial, her trial. So I want to play this while we're on break. I pull this up. Mid hearing. You need to get your. Oh, okay. That's why I was like, your heart. What's the matter with your heart, Cindy? Your hearing. Yeah, I have a little bit of a hearing issue. in one ear. And so I don't know if there's going to be impact statements, and we'll have to wait and see. They haven't said. But I did want to play this. This is only 5 minutes long. It'll take up a few minutes of our waiting for this 15-minute break period while the judge is doing judge things. So with that, I'm going to play this. But yes, I have hearing problems too sometimes. And that's why I always, your eyes up there. That's why I always boost the sound. I always make sure y'all can hear fine. I put the sound to a comfort level for me. And if it's too loud, you should always speak up, because I try to put a comfort level for me, and I always try to add the closed captions and put them in a position where everybody could read them, because it's important to me to be able to read and hear everything. So with that, we're going to play this.
Megan's home life and growing up. But I guess I want to ask you first a little bit about yourself.
Okay.
And I'm asking you these questions, Ms. Boswell. I'm not trying to embarrass you or test any aspersions.
No.
You married Tommy Boswell when you were how old?
First time 15.
You speak into that microphone just a little more, please.
The first time 15.
And when did you become pregnant with your first child with him?
I had my first in April and turned 16 in July. So,
Okay, and who was that child?
Tommy Jr.
Okay. And then you had Megan at some point. How old were you when you had Megan?
There's 8 years difference. I was almost 24.
It's okay. So let's talk about Megan's life growing up. Would it be fair to say that during her lifetime she's witnessed drug use between you and her father?
Yes.
What type of drugs?
Opiates, mainly.
Scoot up and speak into that so the jury can hear you.
Opiates, mainly.
Okay. Did that drug use lead to other problems?
Yeah. Arguments, fighting, yes.
Okay. You say there
strife.
Strife
is what it brings, yes. Nonstop.
Is that something that went on pretty much her entire childhood growing up?
Yeah, from the time she was pretty little, yeah.
Okay. Good. Now, did she witness fights between you and her father?
Yes.
Okay. I think at some point her father was convicted of aggravated assault and kidnapping.
Yes.
Were you the victim in that?
Yes.
Do you remember ever taking Megan to any NAAA meetings with you?
Yes, I did.
How old was she when you did that?
She was probably about 7 or 8. First ones I started taking her to. 7 or 8, 8 or 9, somewhere around in there.
Now she, due to the strife in your home, was she raised by her grandparents to some degree?
Yes.
Okay. What were their names?
Mary and Danny Boswell.
Okay. Mary Boswell, would that be who's known as a mommy?
Yes.
These problems, do you feel that it's partly your fault, the problems Megan's experienced?
No, absolutely. Yes. Yes, absolutely.
Now, unfortunately, your problems, that they went on up into, we saw a video in here, you being brought down from the jail to talk with her in 2020.
Yeah.
So even up until the time she went to jail, you were in and out of jail.
Yeah.
Okay.
Yes. I've been.
Have you been convicted of numerous crimes?
Yes.
Now, have you managed to straighten up at this point?
I have, yes.
You hoping to?
Yes. I pray every day and just, to do my best and try.
Now, have you managed to straighten up at this point?
I have, yes.
You hoping to?
Yes. I pray every day and just, you know, to do my best.
This is this is the end after she was convicted and found guilty. This is the actual stream of court TV when they put the mother on the stand after the sentencing. This was before the judge handed down the sentence. This is the full of her mother, the full testimony of her mother.
And try.
Okay.
I've learned the importance of a mother's role, but not for Megan. I didn't.
All right.
I've failed her on that miserably.
And you're here asking the jury to give her a sentence of life as opposed to life without.
It's Maggie is at her core. She is a generous, kind person, and all Maggie's went through. Maggie still has potential. You know, she was trying so hard. You know, she didn't repeat my mistakes. Maggie learned from my mistakes. And she was trying to do better with Eve. You know, she wasn't repeating. And I think she got saddled with, you know, just because of my mistakes that she did those, and that was not it. That was not the case with that.
Would it be fair to say she didn't have a good role model for the mother should be?
No, she did not.
Answer any of Ms. Massimino or Mr. Harper's questions.
I don't have any questions, Judge.
I will say this. Y'all know me. You don't pass your childhood trauma. You don't pass your trauma, period, onto your child. You try to do better. You may not have been a good parent, but you learn from it. I have so many words, and it's just like I can't verbalize it. She didn't want to. Right, okay, here. Thank you, Cindy. You're keeping me grounded here. She didn't repeat your mistakes. She took them to a whole new level. Right. She has made her own mistakes. You as a mother want to do better for your children. You want your children to be better than you were, better than what you did, better than who you are. I hope every day that my child is a better person than what I was, and she can be a better human than what I was back then. I've learned, I've corrected my mistakes, I've moved on. This mom, bless her heart, she's got her own shit she needs to deal with now, if you want to be frank. And now knowing what her child's done to her grandchild, the trauma now that this woman has to go through, and right, none of us are perfect parents. None of us. We all make mistakes. You can try to say, I was a perfect parent, I never did anything wrong. Bullshit. We all make little mistakes. You may not think of it. It may be something minuscule, but they're there. Nobody's perfect. No matter how much you want to proclaim you're perfect, nobody's perfect. Nobody is perfect. Okay, and I'm sorry, but this bow, even when I remember watching this trial, this bow irritated the piss out of me. You know why? Because it in my mind, this bow and this sweater get up that she's got on is to make her look more of an innocent child, is how I took this. I didn't like it. She's not an innocent child. And yeah, we need to portray her that way in front of the jury or whatever. But I didn't like this. I didn't like it. I felt it was very manipulative of them to dress her like this. My opinion.
Judge, at this time, I have some judgments of conviction on Tommy Boswell. I'd like to put in by agreement with Mr. Harper.
No objection, Judge.
Okay. I'd ask these to be made the next 4 exhibits.
Mr. Scott, I want to enter the case number 61078 as exhibit 263.
I believe somebody else gets on stand. Okay, let's fast forward a little bit.
Speak into the microphone.
Scott, good morning.
Good morning.
Just so I make sure here, spelling your last name, is it K-Y-T-E?
It is.
And Ms. Scott, you've previously testified in this hearing as a state's witness, is that correct?
That's correct.
Well, thank you for coming back for this part of it. I know Ms. Boswell appreciates that. How long have you been working in foster care?
15 years.
Do you remember when Megan Boswell came to you?
I do.
Do you recall what kind of shape she was in or state?
She was in bad shape. She was one of the worst children that I'd brought in as far as neglect.
What do you mean by that?
She was very malnourished. She's very skinny. Her hair was matted to her head with lice. Impossible to even get a comb through.
Okay. Well, when she came to you, were you given any background? I imagine in foster care, you're given background or information of where this child is coming from. Were you giving any of that?
I was.
And what were you preparing for?
In the intake papers, it mentioned trauma. It mentioned rape.
Did it give you any background or any information about her family background or makeup?
Not really.
Okay. Now, you said she came to you with lice. What did you do to try to help Megan?
Well, I took her to a beauty shop because there was no way to even begin to get a comb through. It was horrible. The beauty shop wouldn't touch it. They told me I offered to pay him $100 to go out back to cut her hair. And they said that they couldn't do it. Finally, the agency that we were with found a beautician that met me at a church that was willing to come in and give Megan a haircut. They gave her a bob, which looked really cute on her. But even after that we could get a comb through, it took close to 3 weeks, maybe a month to get rid of the lice. Were just so bad. I had to get prescription medicine from the doctor. We got 2 bottles of that.
All right. We are back. I paused that and moved back. Sorry, I didn't mean to cut her off mid-word, but and we start off with a sidebar. So, it's all good. Okay. His orange computer is just very bold and stands out there. I'm sorry. Squirrel. Just something I noticed.
Determining the appropriate sentence for these offenses. The court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made as sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, with the range 1 being 2 to 4 years. The abuse of the corpse is a Class E felony, and failure to report death under suspicious, unusual, and unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and the mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of proof was that she was approximately 13 months old when she went missing. Is that wrong?
She was, her approximate age at death was 15 months old.
At death?
At death.
Okay. So she was 15 months old.
It was 13 years, 13 months old at death. It was 15 months old, they assumed when she was reported. When they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state, the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. The defendant had no hesitation about committing a crime when the risk to human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, is required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. If the defendant, because of youth or old age, lacks substantial judgment in committing the offense, the proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially, from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision.
Tough words,
to remove
Judge.
that
Tough
stumbling
words. Stumbling block.
And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. she exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing. When the court weighs the enhancing factors and the mitigating factors, that's how I arrive at a verdict, or not a verdict, but a sentence. I want to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity to those two counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion, in counts 4 and 5, that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge, counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3
would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And of course, I just so clarify, it wasn't a mistake, but at the time it was filed, when we had all the false report counts, rely on that criminal history. Obviously, since the court's longer, more duplicitous, that doesn't exist anymore. So we're not relying on that.
Quick objection. The court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little to no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But as pointed out in State versus Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the main case is the Wilkerson case, 905 Southwest 2nd. (933) Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 40-35-115 enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a sentence, consecutive sentencing, is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first, there's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake. A lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy.
Nope, not even today. Not even
Out of
today.
the defendant. So she is a dangerous offender.
Thank you, Judge.
The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom.
Only way the baby could get through the day was
And
with
I
her mom.
understand that the way the
And you failed her.
parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child. The court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 it's found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar, you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for the trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, share, I'll do it.
Judge, I would also like to have this sentencing hearing as well.
The sentencing hearing will need to be talked up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine, but I'll wait Ms. Boswell's appearance.
Well, what I prefer her to do is appear by Zoom.
That's
If-
fine.
If she can, but if not, yes, we can.
Okay.
Fine. All right, that's all.
Okay. Well, all righty. So with that, she will serve the 51 years, and then she will have a 25-year after that, serve consecutively. The other charges would run concurrent, is what I got and understood out of that. And yes, she gone. Goodbye, Megan. We are done. She has a hearing on January 16th. She will appear by Zoom. I am totally disgusted with her statement in front of the courts. That was so telling of who she is, her entitlement, her demeanor, which it is what it is. She took her child's life. She's convicted. She's done. And she will serve the time. And with that, we now have a baby Evelyn Boswell law in Tennessee. I'm not in the state of Tennessee, but if you are required within 24 hours of your child missing to report it. Oh my goodness. I just had something go off crazy in my background. So with that, justice for baby Evelyn. And I hope everybody knows that your trauma is yours. Do not pass it to your children. Only hope for the better for your children. Children deserve to be hugged and loved and shown compassion. And with that, I'm going to get emotional. I want everybody to go out, touch grass, watch the clouds roll by, hug somebody you love, make a phone call, a text. Be there. Be there. Be there for your friend. You may not know that they need help and they're reaching out. I talked to somebody for 2 hours last night as a friend. She knows who she is. She knows I love her. And always, if you ever need somebody, reach out, whether it's to me or somebody else. I'm always here. Y'all know I'm a very open person. Yeah, with that, I want everybody to have a great rest of your weekend. I'm going to get back to my regular schedule on Monday. I'll be back at 1 o'clock. Monday, we'll continue with the Dinkins. I know it's an old trial. It's something for us to do. I think there was actually a new trial coming up. Oh, wait. Let's see. Iowa versus Dakota Van Patten. We might pivot. I need to look into this. My calendar. I write everything. I have a writing problem. If y'all could only see all my scribbles, all during this, my scribbles would make no sense to anybody, but I know what they are. Yeah, so I don't know. We may pivot and pick back up on Dinkins. I need to look into this Dakota Van Patten. I'm not sure what it is. True Crime Celebrity News is the one that gave it to me. If you're not a fan of hers, or not a fan, not subbed up to her, give her a sub. Yeah, I'm going to look into this. I'm going to look into this and see what I come up and figure out what's going on for Monday. If I can find it, we might do that. We might pivot and come back to Dinkins. I don't know. Not to cause any confusion, but we'll see. With that, I want you all to have a great rest of your weekend. Go outside, touch some grass, watch the clouds roll by, and until Monday, I want y'all to have a great rest of your weekend. And with that,
Life's a ride on a rickety old track.